Hello students, welcome to the lecture on industrial disputes and discipline. And after this lecture we will be able to learn the following objectives. Explain the concepts of disputes. Define the concepts and nature of industrial dispute. Discuss the forms of industrial disputes. Understand the industrial dispute causes. Define the dispute resolution. Describe the meaning and techniques of conflicts. Explain the meaning, objectives, and approach of discipline. Understand the maintenance of discipline. Discuss the causes of indiscipline. Let's start with some introduction first. Industrial disputes are organized protests against existing terms of employment or conditions of work. According to the Industrial Dispute Act, an industrial dispute means any dispute or difference between employer and employer, or between employer and workman, or between workmen and workmen, which are connected with the employment or non-employment or terms of employment or with the conditions of labor of any person. Let us first discuss about the concepts of disputes. Disputes in the workplace between employees and employers, or indeed between employees and their colleagues, inevitably happen from time to time. They can arise out of a whole range of circumstances, including, but not limited to, simple misunderstandings, or mistakes, poor communication and decision-making, tensions or personal difficulties, breaches of trust or of the law, infringements of personal dignity or human rights, inability or unwillingness to perform allocated work, unacceptable behavior, and so on. Employee self-esteem, morale, and productivity can be harmed, as can their longer-term employment prospects. Negative effects on business productivity, reputation, employee motivation, and workplace relationships can also be expected. Disputes carry costs in both monetary and psychological terms. Disputes, nonetheless, are a fact of life. They will always occur. Not all can be prevented or avoided. Let us now understand the concepts and nature of industrial dispute. The consequences of an industrial dispute will be harmful to the owners of industries, workers, economy, and the nation as a whole, which results in loss of productivity, profits, market share, and even closure of the plant. Hence, industrial disputes need to be averted by all means. Prevention of industrial disputes is a proactive approach in which an organization undertakes various actions through which the occurrence of industrial disputes is prevented. Concept. Industrial disputes are organized protests against existing terms of employment or conditions of work. Nature. An industrial dispute may be defined as a conflict or difference of opinion between management and workers on the terms of employment. It is a disagreement between the employer and employee's representative, usually a trade union, over pay and other working conditions, and can result in industrial actions. When an industrial dispute occurs, both the parties, that is, the management and the workmen, try to pressurize each other. The management may resort to lockouts, while the workers may resort to strikes, picketing, or guerrero. The disputes generally arise on account of poor wage structure or poor working conditions. This disagreement or difference could be on any matter concerning the workers individually or collectively. It must be connected with employment or non-employment or with the conditions of labor. Let us now understand about the forms of industrial disputes. Strikes, lockouts, and guerrero are the most common forms of disputes. Strike. Strike means a cessation of work by a body of persons employed in any industry acting in combination, or a concerted refusal, or a refusal under a common understanding or a number of persons who are or have been so employed to continue to work or to accept employment. The following points may be noted regarding the definition of strike. Strike can take place only when there is a cessation of work or refusal to work by the workmen acting in combination or in a concerted manner. A concerted refusal or a refusal under a common understanding of any number of persons to continue to work or to accept employment will amount to a strike. If on the sudden death of a fellow worker, the workmen acting in concert refuse to resume work, it amounts to a strike. The striking workman must be employed in an industry which has not been closed down. Even when workmen cease to work, the relationship of employers and employees is deemed to continue, albeit in a state of belligerent suspension. Types of strike. Stay-in, sit-down, pen-down strike. In all such cases, the workmen, after taking their seats, refuse to do work. All such acts on the part of the workmen acting in combination amount to a strike. Go slow. Go slow does not amount to strike, but it is a serious cause of misconduct. Sympathetic strike. Cessation of work in the support of the demands of workmen belonging to other employer is called a sympathetic strike. Hunger strike. Some workers may resort to fast on or near the place of work or residence of the employers. Lightning or wildcat strike. A wildcat strike is an unofficial strike. Example, a strike not sanctioned by the union. Work to rule. Since there is no cessation of work, it does not constitute a strike. Economic strike. Under this type of strike, laborers stop their work to enforce their economic demands, such as wages and bonus. General strike. It means a strike by members of all or most of the unions in a region or an industry. It may be a strike of all the workers in a particular region of industry to force demands common to all the workers. Regulation of strikes. Strikes would come under the classification of collective disputes. The forum for their resolution is the industrial court. However, unlike in England or the United States, where the immediate remedy to break a crippling strike is the controversial labor injunction, there is no provision under the Act for the Industrial Court to grant injunctive relief. A national strike, which threatens an industry or cripples an essential service in the country, would never be allowed to run its course. It declares that workmen shall not go on strike after a trade dispute involving them has been referred to the court. Strikes can occur because of the following reasons: dissatisfaction with company policy, salary and incentive problems, increment not up to the mark, wrongful discharge or dismissal of workmen, withdrawal of any concession or privilege, hours of work and rest intervals, leaves with wages and holidays, bonus, profit sharing, provident fund and gratuity, retrenchment of workmen and closure of establishment, dispute connected with minimum wages. Lockout. The Industrial Disputes Act defines lockout to mean the temporary closing of a place of employment or the suspension of work, or the refusal by an employer to continue to employ any number of persons employed by him. Lockout, thus, is the counterpart of strike, the corresponding weapon in the hands of employer to resist the collective demands of workmen or to enforce his terms. It has been held by the courts that the suspension of work as a disciplinary measure does not amount to lockout. Similarly, temporary suspension of work, called layoff, is not lockout. A lockout is a work stoppage in which an employer prevents employees from working. It is declared by employers to put pressure on their workers. This is different from a strike in which employees refuse to work. Thus, a lockout is employers' weapon while a strike is raised on part of employees. A lockout may happen for several reasons, unless the limited court appeal is made. May be less formal in structure than going to court, depending on applicable arbitration rules. Usually quicker and less expensive than going to court. Types of lockout. Picketing. When workers are dissuaded from work by stationing certain men at the factory gates, such a step is known as picketing. If picketing does not involve any violence, it is perfectly legal. Pickets are workers who are on strike, that stand at the entrance to their workplace. The purpose of picketing is to stop or persuade workers not to go to work, to tell the public about the strike, to persuade workers to take their union's side. Regulation of lockout. Employees do not have an unfettered right to go on strike, nor do employers have such right to impose lockout. The Industrial Disputes Act lays down several restrictions on the rights of both the parties. A strike or lockout commenced or continued in contravention of those restrictions is termed illegal, and there is served punishment provided for the same. Consequences of lockouts. Penalty for illegal strikes. Any workman who commences, continues, or otherwise acts in furtherance of a strike which is illegal shall be punishable with imprisonment for a term which may extend to 1 month, or with fine which may extend to $1, or with both. Penalty for illegal lockout. An employer who commences, continues, or otherwise acts in furtherance of a lockout which is illegal shall be punishable with imprisonment for a term which may extend to 1 month, or with fine which may extend to $20, or with both. Gareo. Gareo means encirclement of the managers to criminally intimidate him to accept the demands of the workers. Gareo in Hindi means to surround. It denotes a collective action initiated by a group of workers under which members of the management are prohibited from leaving the industrial establishment premises by workers who block the exit gates by forming human barricades. Let us now discuss industrial dispute causes. The causes of industrial conflict or disputes have been much varied. These may be described partly as psychological or social and partly political, but predominantly economic. Some important factors responsible for industrial conflict and poor industrial relations, many are management's general apathetic towards workers or employees because of their contention that they want more and more economic or monetary rewards and want to do less work. Mental inertia on the part of both management and labor. Lack of proper fixation of wages in conformity with cost of living and a reasonable wage structure generally. Bad working conditions. Attempts by management to introduce changes, such a rationalization, modernization, or automation without creating a favorable to appropriate climate or environment for the same. Assignment of unduly heavy workloads to worker, unfair labor practices, such as victimization or undue dismissal. Dispute resolution generally refers to one of several different processes used to resolve disputes between parties, including negotiation, mediation, arbitration, collaborative law, and litigation. Dispute resolution is the process of resolving a dispute or a conflict by meeting at least some of each side's needs and addressing their interests. The dispute resolution process is a participatory and creative process and is required prior to filing a grievance to a decision maker. In the complaint process, the dispute resolution officer, as an impartial third party, will consult individually with us and with supervisor to gather relevant information. identify both of issues and interests, and explore options for resolution. Appropriate dispute resolution, ADR, as it is commonly called, comprises arbitration, mediation, conciliation, and negotiation. These time-proven processes are the alternatives to seeking settlement of disputes through the courts. Some of the benefits of using ADR can be completed quickly. Schedules to suit the parties. Confidentiality. ADR settlements are a private matter between the parties, and there is no public record. ADR is generally voluntary except where it is required by contract or by statute. Negotiation. Negotiation is a less structured form of ADR. The facilitator's role is to keep the parties talking and bargaining. The parties may be individuals or teams. The facilitator keeps record of party positions and points of agreement they reach as discussions proceed. The process can be lengthy, as in labor or sports negotiation. The facilitator will prepare a memorandum of agreement containing all of the points agreed. Mediation, the parties decide. A dispute resolution process in which the parties freely choose to participate and any agreements reached to settle disputes is done solely by the parties, without interference. The mediator is selected by the parties, and once selected, the mediator will arrange the mediation process. The mediator makes no decisions. Instead, he/she acts as a facilitator only to assist the parties to understand the dispute, provide structured discussion, and to help the parties reach a dispute settlement agreement. Government machinery. The Ministry of Labor and Employment at the center is the key agency for the policy formulation and administration in all the matters pertaining to labor. The state governments, with the cooperation of their labor departments, are responsible for the enforcement thereof. The Directorate General of Employment and Training, DGET, Office of Cheap Labor Commissioner, CLC Central, the Director General of Mine Safety, DGMS, the Director General of Factory Advice and Labor Institutes, and industrial tribunals are some of the agencies through which the central government discharges its functions related to framing of labor laws and settlement of industrial disputes. Did you know? During 1956 to 57, an alarming number of cases of violence and intimidation, strikes and lockouts were recorded. Arbitration. Arbitration is a dispute resolution process where the opposing parties select or appoint an individual called an arbitrator. Upon appointment, the arbitrator will arrange the process to hear and consider the evidence, review arguments, and afterwards will publish an award in which the items of dispute are decided. In some cases, the arbitrator can conduct the arbitration on documents evidence only. Characteristics of arbitration. Can be used voluntarily. Private, unless the limited court appeal is made. May be less formal in structure than going to court, depending on applicable arbitration rules. Usually quicker and less expensive than going to court, depending on applicable arbitration rules. Each party will have the opportunity to present evidence and make arguments. May have a right to choose an arbitrator with specialized expertise. Let us move to meaning and techniques of conflicts. To come into collision or disagreement, be contradictory, at variance, or in opposition, clash, the account of one eyewitness conflicted with that of the other. Conflict resolution techniques. The choice of an appropriate conflict resolution technique depends on a number of factors, including why the conflict occurred, the relation between the conflicting parties, and the relationship between the principal and the conflicting parties. Most of these techniques rest on one model which consists of 4 steps. Identify or clarify the issues. Search for shared values. Explore possible solutions. Select the solution that satisfies those who have the conflict. Preventative techniques. Several techniques fall within this category. 1. Personal qualifications of the principal, promoting and becoming involved in morale-boosting social events for staff, students, and parents. 2. Promoting effective up-down and down-up communication. 3. Altering behavior through motivational seminars, peer evaluation, mentoring, etc. Types of conflicts. There are 2 types of conflict. 1. Substantive conflict, and 2. Affective conflict. A substantive conflict is associated with the job, not individuals, while an affective conflict is drawn from emotions.
Hello everyone, I want to talk very briefly about causes of conflict since we'll be studying it over the next few weeks. I want to talk about why we'd study it and how, but first of all I want to talk about what is a conflict. So conflict is defined as a serious disagreement or argument. In history, it would be a war, fights, battles, disputes, all of that bad stuff. So why would we study the causes of a conflict? Well, conflicts are not inevitable. That means that they can be avoided. They don't have to happen. If we understand conflict and what causes it, then we can avoid it in the future. So how do we study the causes of a conflict? Well, in order to figure out the why of a conflict, we should study the conflict's background. So in order to figure out the why, we should study the who, the what, the when, and the where. We should study who was involved, what happened, when did it happen, and where did it happen. This will help us figure out the why that it happened and the causes of it. So to review, we study it to avoid it. We study the causes so that we can avoid conflict because it is avoidable. We can figure out the why or the cause of the conflict by studying the background of the conflict, meaning the who, what, when, and where of the conflict. And this will be we'll be moving forward after studying the background. We will look at the cause and effects of key events that led to the conflict, and we'll also take a side and make a decision about what we think the major causes of the conflict were.
Let us now discuss about discipline. Discipline may be defined as an attitude of mind which aims at inculcating restraint, orderly behavior, and respect for and willing obedience to a recognized authority. In any industry, discipline is a useful tool for developing, improving, and stabilizing the personality of workers. Industrial discipline is essential for the smooth running of an organization, for increasing production and productivity, for the maintenance of industrial peace, and for the prosperity of the industry and the nation. It is a process of bringing multifarious advantages to the organization and its employees. Meaning of discipline. Discipline is the force that prompts an individual or a group to observe the rules, regulations, and procedures which are deemed to be necessary to the attainment of an objective. It is force or fear of force which restrains an individual or a group from doing things which are deemed to be destructive of group objectives. There are two types of discipline. One is positive and the other is negative. Positive discipline employs constructive force to secure its compliance. It is immeasurably more effective and plays a greater role in business management. Negative discipline, on the other hand, includes both the application of penalties for violation and the fear of penalties that serve as a deterrent to violation. Aims and objectives. The main aims and objectives of discipline are to obtain a willing acceptance of the rules, regulations, and procedures of an organization so that organizational objectives can be attained. To develop among the employees a spirit of tolerance and a desire to make adjustments. To give and seek direction and responsibility. To create an atmosphere of respect for human personality and human relations. To increase the working efficiency morale of the employees. Approaches to discipline enforcement. The different approaches to discipline include human relations approach. The employee is treated as human being and his acts of indiscipline will be dealt from the viewpoint of human values, aspirations, problems, needs, goals, behaviors, etc. In this approach, the employee is helped to correct his deviations. Human resources approach. The employee is considered as a resource, as an asset to the organization. This approach analyzes the cause of indiscipline from management activities such as defects and selections, training, motivations, leadership, etc. After identifying the defects, corrective steps are carried out by the management. Group discipline approach. Group as a whole sets the standard of disciplines and punishments for the deviations. In this approach, trade unions also act as agencies in maintaining discipline in a work situation. The leadership approach. The leadership approach in disciplinary cases is dealt on the basis of legislations and court decisions. Did you know? The Workmen's Compensation Act 1923 provides for the payment of compensation of workmen who meet the accident arising out of and in the course of their duties. Disciplinary actions have serious repercussions on the employees and on the industry, and therefore must be based on certain principles in order to be fair, just, and acceptable to the employee and their unions. Therefore, in any discipline maintenance system, certain principles are to be observed, such as the rules of discipline, as far as possible, should be framed in cooperation and collaboration with the representatives of employees for their easy implementation. The rules and regulations should be appraised at frequent and regular intervals to ensure that they are appropriate, sensible, and useful. The rules and regulations should be flexible to suit different categories of employees in the organization, that is, both the blue-collar workers and white-collar employees. Every kind of disciplinary penalty, even if it is a rebuke or a warning, should be recorded. A punitive action must satisfy the principle of natural justice. Code of discipline. There should be no lockout or strike without notice. No unilateral action should be taken in connection with any industrial matter. There should be no recourse to go-slow tactics. No deliberate damage should be caused to plant or property. Acts of violence, intimidation, coercion, or instigation should not be resorted to. The existing machinery for settlement of disputes should be utilized. Awards and agreements should be speedily implemented. Any agreement which disturbs cordial industrial relations should be avoided. The Code embodies 4 parts. Part 1 contains the duties and responsibilities of employees, workers, and the government in maintaining discipline in industry. Part 2 enlists the common obligations of management and unions. Part 3 deals with the obligations of management only, while Part 4 relates to those of the unions only. The term indiscipline generally means the violation of formal or informal rules and regulations in an organization. Causes for indiscipline in organizations. The reasons could range anything from poor wages to poor management, and the communication gaps between the union and management. The common causes of indiscipline are 1. Unfair management practices. Management sometimes indulges in unfair practices like A. Wage discrimination. B. Non-compliance with promotional policies and transfer policies. C. Discrimination in allotment of work. D. Defective handling of grievances. E. Payment of low wages. F. Delay in payment of wages. G. Creating low-quality work life, etc. 2. Absence of effective leadership. Absence of effective leadership results in poor management in the areas of direction, guidance, instructions, etc. This in turn results in indiscipline. 3. Communication barriers. Communication barriers and absence of humane approach on the part of superiors result in frustration and indiscipline among the workers. 4. Varying disciplinary measures. Consistent disciplinary actions must be there in the organization to provide equal justice to all concerned. 5. Defective supervision. Supervisor is the immediate boss of the workers, and many disciplinary problems have their in faulty supervision. 6. Absence of code of conduct. This creates confusion and also provides chance for discrimination while taking disciplinary action. A domestic inquiry is an internal hearing held by an employer to ascertain whether an employee is guilty of misconduct. The purpose of a domestic inquiry is to find out the truth of the allegations made against the workman. In conducting a domestic inquiry, the rules of natural justice must be adhered to. Justice must not only be done, but must be seen to be done, the 2 pillars of natural justice being, no person shall be condemned unheard, and no person shall sit in judgment in his own cause or in any in which he is interested. Domestic inquiry is an internal inquiry into some alleged misconduct by an employee. The main objectives of the domestic inquiry are to establish whether the employee is guilty on the allegation. Principles of natural justice. The principles of natural justice have been developed and followed by the judiciary to protect the right of the public against the arbitrariness of the administrative authorities. Natural justice implies fairness, reasonableness, equity, and equality. It is the concept of the common law. The aim of natural justice is to secure justice, to prevent miscarriage of justice, and to give protection to the public against the arbitrariness. Principles of hot stove rule. Hot stove principle is a human resources management in the formulation, referring to the criticism of people's wants, the same as the hot stove. Follow the warning, the same instant, the principle of fairness. Now in the end, let us summarize what we have learned in this lecture. A conflict or controversy, a conflict of claims or rights, an assertion of a right, claim, or demand on one side, met by contrary claims or allegations on the other. Any dispute or difference between employer and employer, or between employer and workman, or between workman and workman, which are connected with the employment, or non-employment, or terms of employment, or with the conditions of labor of any person. An industrial dispute may be defined as a conflict or difference of opinion between management and workers on the terms of employment. Strike means a cessation of work by a body of persons employed in any industry acting in combination, or a concerted refusal, or a refusal under a common understanding, or a number of persons who are or have been so employed to continue to work or to accept employment.